personal computer was not working with Zoom. I don't know why, probably because I haven't updated the Zoom program. These are the mysteries of our, can you hear me?
Yes, yes.
Okay, great.
Yes.
Let me put extra voice from my computer. Okay. Welcome to the session on of the constitutional in constitutional law, comparative constitutional law. Hello, dear colleagues. Hello, all the people that are going to the scholars that are going to present our their papers. And the first speaker of today is Enrico Andreoli from the University of Verona. Please, Dr. Andreoli, enter in our conference, and the floor is yours.
Thank you. Can you hear me correctly?
Oh, yes.
Okay. Thank you. Thank you, Professor Violini. So good morning, everyone. First of all, I would like to thank the organizer for allowing me to speak at this panel alongside such prestigious colleagues whom I greet with enthusiasm. I also want to express my sincere compliments for the rearrangement of the original panels due to the circumstances unfortunately known and affecting the life, work, and not of all of us. As this panel deals with comparative constitutional law, you might consider it curious that I start my presentation by making reference to semantic transformation, as you can see from the title of my presentation. That is a topic which is not necessarily legal technical in a traditional sense. I contend, however, that semantics has to do with the law. Indeed, language is not a neutral factor which intertwines both with the creation of legal texts and in their subsequent interpretation. We can talk in this regard about the impact that lexicology can have on legal significance, where lexicology has to be intended as the study of words and their meaning and use. In constitutional legal terms, evidently, it should be specified that the present analysis is not intended to be part of the historical and often bitter debate on how to make constitutional interpretation, the one regarding originalism, textualism, and so on. This work is placed, so to speak, at a time before the meaning to be attributed to a certain interpretation of the Constitution. I intend to investigate, in fact, the possibility that the meaning of the interpretation rendered by the judicial body in the US constitutionalism, and in particular, that rendered by the Supreme Court as the top court of the constitutional system, may vary as the lexical and semantical signifiers vary. This consideration seems to be valid because, as noted, written language is pragmatically enriched within contexts where the law is interpreted or performed, and the linguistic notion of context discloses the interrelations between the agendas of law and power and reveals how the law conveys its concept. Moving to the context within this research is located, it is as evident that of US constitutionalism. In particular, it is located inside the relationship between the constitutional text and its interpretation by the constitutional actors. The historical datum of US constitutionalism returns the evidence that the intrinsic intention of the US Constitution was to establish a sort of unified government. It must be read this way, for example, the delegation of powers to each of the constitutional actors, a circumstance that will later give rise to what has become known as the departmental theory. Within this division, the judiciary power is the one authorized to ensure that the other powers act in a manner consistent with the constitutional text and to control acts which are not coherent with the Constitution. From a hierarchical point of view, the Supreme Court is the highest court in the US, as obviously known. Its leading role stems from a precise constitutional choice, given that it is the only constitutionally mandatory court. It is stated in the Article 4 in the organization of the judiciary with the words "one Supreme Court." This leading role tends to pose the Supreme Court as the main interpreter of the laws and constitution in the US constitutionalism, and in particular in the judiciary of the US constitutionalism. It is a fact, though, that the overall understanding and interpretation of the Constitution made by the Supreme Court as a top court has changed over time. And there are many circumstances that justify a different interpretation of a normative act. For example, social sensitivity, cultural factors, political preferences. But in my opinion, there is another factor, and it is the language used in the legal documents. The language in the Constitution as a legal document is especially ambiguous, allowing for multiple possible understandings of the real meaning of the text. And given that also this linguistic ambiguity to me seems to be one reason for variation in the understandings or interpretations of the Constitution. Generally speaking, linguistic ambiguity in legal documents can be attributed to several factors. But in the US Constitution, the two most likely reasons of this ambiguity are lexical and syntactic. The first source of ambiguity, the lexical one, addresses the differences in meanings of individual words. For example, the word jurisdiction in Article 3, where jurisdiction has not a unique meaning. Lexical ambiguity presupposes that no meaning of a word is necessarily incorrect, as many words have, as I said, developed multiple meanings over the history of the English language. It is clear then that this ability for legal words to convey different meaning in specific context could affect the no less problematic ambiguity on interpretation of the constitutional text. The second source of ambiguities in the US Constitution, the syntactic one, refers to the complexity resulting in the understanding of the overall meaning. In phrases, vagueness may be even more obvious than in words. As mentioned at beginning, even if a phrase is clear in one context, it may be unclear when given a somewhat different context. And based on the above, the linguistic ambiguity is also inherent in the constitutional text as a legal one. And it opens to any number of possible constitutional interpretations made by the judiciary and especially by the Supreme Court. The question so is, can this linguistic ambiguity of the Constitution affect the role of judicial interpretation? Through these premises, it can be noted that there are certain parts of the Constitution that return evidences of linguistic ambiguity. Since a list is not intended to be exhaustive, it is indicative that the main examples of ambiguities of constitutional interpretation made by the Supreme Court of the United States come from the literal data of the amendments to the constitutional text. The first part that can be analyzed is the First Amendment, which, among others, addresses the freedom of the press. In a case decided by the Supreme Court in 1938, Lovell versus City of Griffin, the Supreme Court decided on the issue of whether or not a local city government could require a person to receive written permission from a city manager to distribute literature. In a unanimous decision, the Supreme Court decided that this was an unconstitutional statute. The words of the First Amendment expressly states that Congress shall make no law respecting, etc., abridging the freedom of speech or of the press. So although the word mentioned in the Constitution is Congress, is expressly Congress, the First Amendment for in this Supreme Court case has been extended to apply to all forms of government. There is no contemplation of a sort of ambiguity. The justices clearly take the word no shall make no law as an absolute and in a way no open to interpretation. Otherwise, in another famous case, New York Times Company versus United States of 1971, it was addressed the issue of whether or not President Nixon administration violated the First Amendment in trying to prevent publication of classified information. And the majority of the Supreme Court held that the action of the administration had been unconstitutional. The Nixon administration in this case claimed that the government could have been in danger if the press had released the classified information. Yet the majority of the Supreme Court justices believed that this danger was evident enough to overcome the First Amendment freedom of press. So in this case, the justices were more likely to acknowledge the possible ambiguity of the words and phrases within the First Amendment, especially in the case as it concerns matters of national security. Another example of ambiguity in the Constitution is the Section 1 of the 14th Amendment, for which it is imperative to ensure the rights of all those who are determined to be citizens of the US to be recognized as such. In an old case, Hurtado versus People of the State of California of 1884, the Supreme Court addressed the issue of whether or not the due process clause inserted in the 14th Amendment requires indictment by a grand jury in a state criminal prosecution. In this case, the Supreme Court decided against the accused, stating that due process contained in the amendment did not include indictment by a grand jury within a state prosecution. So,
I'm sorry to interrupt you, but I think you had 20 minutes and the 20 minutes are expired. We started at 10:10 and now is 10:25. So keep an eye to your time. Okay.
Yes, I have more or less 5 minutes more.
Okay, this is why I was preventing you for going ahead.
No, I'm
indefinitely.
Okay.
Okay, so, go ahead.
So in this case, the Supreme Court decided, as I said, and the opinion of the court seems to be a strictly textual interpretation of the due process clause. Since there is no mention of a grand jury indictment, the justices took the clause to have no ambiguity in the interpretation. In another case, Jacobson versus Commonwealth of Massachusetts, the issue was whether or not under the due process clause, an individual has the right to be exempted from a state law requiring vaccination for a disease. But the point is that in this case, the Supreme Court found that the list of deprivation of life, liberty, or property was ambiguous, and the majority of the Supreme Court decided that the lexical ambiguity contained in the word liberty did not encompass exemptions that could risk the welfare of the state. Another ambiguity could stem from the 15th Amendment with another contraposition with a case, for example, Plessy versus Ferguson, where the clause was interpreted with an ambiguous meaning, and another one, Lane versus Wilson, where the case was intended to be a no ambiguous interpretation of the 15th Amendment. So all these examples show that without linguistic ambiguity within the Constitution, the variety of constitutional interpretation could not be possible. And indeed, the ambiguous significances of the Constitution are a large reason for its ability to be reviewed and interpreted in a diverse number of ways. And as often as judicial views on the Constitution change, so do the meanings of the words and phrases on which those judicial views are founded. So from this point of view, the dynamically ambiguous nature of the legal language used in the Constitution has been a factor in judicial interpretation. And indeed, from a lexicology standpoint, such variations in constitutional interpretation, in conclusion, could be placed in the same way as sorts of possible continuous living amendments to the meaning of the constitutional text. And that's why I addresses the Supreme Court as a possible amender of the Constitution in a syntactical way.
Thank you very much for your presentation. We have now time to discuss your presentation, and everybody is welcome to give questions, and I open the floor to questions.
May I say something?
Sure.
Thank you.
Of course. Ciao, Alessandro.
And
ciao,
ciao. Thank you for your presentation, which was very interesting. I wonder if what you call ambiguity of words in the Constitution could be a point of reference for saying that in reality, what we call interpretation and what we think it is a philosophical problem to find out the real sense of a word, or to find out a plausible sense of a word, or a shared sense of a word, is in reality a political problem. We do not try to find out the real meaning or a plausible meaning. We are interested in finding out a meaning which is politically interesting for our position, for the value we share, and so on. And what you name ambiguity seems to me the point of contact between the idea that interpretation is a philosophical problem and the reality, to me, that interpretation is in fact a political problem. Did I understand well what you somehow wanted to also to say with your presentation? Thank you.
Yes, thank you for the question. Yes, I completely understand, and that's why I made a reference to the debate about how to make constitutional interpretation. Obviously, the position of the Supreme Court in the constitutional architecture of the US constitutionalism is a sort of ambiguity for itself. is ambiguous for itself because it is not a political institution in a very strict sense, but it refers to politics, and it is obviously an institution capable to make politics in the US constitutionalism. So I agree that when we think about the meaning of constitutional interpretation, there is a sort of a research of an outcome. There is a political interpretation because the justices of the Supreme Court are obviously in a sort of way, they are political actors because they are appointed in a sort of political process, and they probably try to understand the constitution politically. So I agree that there is a sort of connection between a philosophical way to interpret the constitution, and probably my presentation refers particularly to the syntactic and lexicology, and it is a sort of interpretation without the context. I don't know if I'm able to speak to say it, because obviously when the interpretation goes into the process of the political process or of the judiciary and political process, obviously the interpretation has a concrete meaning and a political meaning. It is a research of an outcome. Every interpretation, every judiciary interpretation probably is the research of an outcome in the constitutional process and in constitutional adjudications. So I was trying to figure out if interpretation could be not political, but not with no reference to other sources than the lexical ambiguity and syntactic ambiguity. So I was trying to understand if the text of concrete legal English could be one reason for a change of interpretation. Obviously, obviously, if this research will go further, it is not possible to not comprehend your point. So the point that there is a political interpretation and there is a search of something more than the change in the text. But I was trying to understand if this possible multiple interpretations could lies on the variations of the text, so of the concrete words and phrases in the Constitution. So, but I completely understand that it is difficult to, in a possible development of this research, not to refer to your point, so the political interpretation of the text. I don't know if I answer.
Lorenza, also.
So, who is?
I've raised my hand. If you look at the chat, Lorenza, you see who has raised the hand, and if they are, and you look also at the question and answers and the chat, you see if someone is asking to intervene. At this moment, if I can say something, Lorenza, you are muted. If you don't put your microphone is off.
No, that's fine. Listen, my chat is blocked by one message you send to me, Vincenzo, and I'm unfortunately.
You just have to go on chat. You just go on and you just go on and you scroll it down. Sorry if I sort of give these very practical information, but you just scroll it
No,
down.
no, that's fine. That's fine. I'm very interested in practical information, and but now,
okay, if I can say something, sort of to Andreoli. First, I don't want to sort of kill his report, but with one of those quotes that I imagine he knows, he has studied. The quotation is an obvious quotation from Alice in Wonderland, when Humpty Dumpty says, "When I use a word, it means just what I choose it to mean, neither more nor less." And I have the impression that when it comes to interpretation, well, most interpreters use the Humpty Dumpty policy. I mean, they say what they mean to say, and that's it. But moving in a more constructive way, I would just suggest to Andreoli to expand his research in the field of semiotics, in the sense that semantics, well, it's important, and sort of understanding how words change, and obviously there's a great deal of research of experts in language, and just to think of the great Finnish school. So just to point out that that is quite obvious. I think that maybe some insights may come from semiotic investigation in the words used by lawyers and by the constitutional courts, because this gives us a more contextual, gives us a broader view, not only focusing on how the words are interpreted. But this is just a simple suggestion by someone who's sort of doesn't really work on both in these fields, but thinks that these are fields that are worth discovering and investigating more.
Yes, thank you so much for the suggestion. It is a great suggestion. Yes, I appreciate it. Thank you so much.
Lorenza, devi tenere il microfono acceso. Se tu non tieni il microfono acceso, poi sempre acceso, poi hai difficoltà a intervenire.
No, va bene, sì, sì, certo, cioè, lo tenevo spento anche per evitare che l'ambiente intorno, che non è particolarmente rilassato, crei dei disturbi alla discussione. Bene, so adesso, now, thank you to Enrico Andreoli and to the colleagues that gave questions to him. And now I give the floor to BARGIACCHI, Stefano, and BONIFATI, Lidia. BARGIACCHI Stefano is a PhD student from Siena, a city I love you very much, and BONIFATI Lidia from Bologna. Who's going to speak first?
I'm going to start the presentation.
Okay, and please, I haven't done this before with Enrico Andreoli, but I would like you to say something from your profile, so just introduce yourself to the audience.
Okay, don't worry. Okay, and good morning, everyone, and thank you so much for the opportunity to be here. I want to thank also the organizing committee for the incredible job in the creation of this event. I am Stefano BARGIACCHI, as Professor VIOLINI said. I'm a PhD candidate from the University of Siena, and I'm conducting my PhD dissertation in parliamentary law, and in particular in the appointing power of national parliament of Europe. The aim of this work is to explore the role of the Speaker of the House of Commons during the Brexit period of constitutional distress. The definition of Brexit, like a period of constitutional distress, will be made by my colleague Lidia. In the first part of my speech, I will spend some words on the classification of the presidents of parliamentary assemblies in comparative law. Then I will present a classical definition of the House of Commons Speaker role, and then I will analyze how the role of the Speaker is changed during Brexit. I think that a good starting point in order to classify the precedence of parliamentary assemblies in comparative law, it could be the work of Stanley Buck. Sorry? Okay. I think that.
Okay, go ahead, Stefano.
Oh, okay, excuse me.
No, someone went in and he was speaking with the unmute.
Okay, sorry.
So we were disturbed by him, but that's fine. So go ahead.
Okay. Okay, I think that in order to classify the precedence of parliamentary assemblies in a comparative way, a good starting point could be the work of Buck. In his perspective, the first element that should be considered is the essential duplicity of the role of the Speaker of the House. Often, I think that there is an essential incompatibility of several roles that the Speaker must play. In particular, I think that using an image that is quite common among the Italian scholars, the image of the so-called Giano bifronte, double-faced Janus, is quite useful to explain this duplicity of the Speaker. If we think that one of the two faces of the Janus is oriented inside the assembly, with the role to interact in an impartial way in order to preserve the dignity of the House, the prerogative of the House, and to interpret in a fair way the standing orders, while the other face of the Janus is oriented to the political arena, with the President of the Parliament that could play, and often plays, an active role in the political game. I think that starting from this image, we can try to figure out a classification of the office of the Speaker in a 6 dimensions. I'm not going to present in detail all those 6 dimensions. Some of them are related to the role of the Speaker in the management activity of the House. Other ones are connected to the role of the Speaker, like the President of the Assembly and his power to control the agenda or control or interpret the standing order. My point is that this classification, according to the most part of the scholar, allow us to consider a large spectrum of possibilities, with at the extreme of this spectrum 2 possible archetypes. The first one is the so-called partisan speaker, a speaker that is elected by the majority of the assembly, that he is accountable to the majority of the assembly, is the role not only to precede the House, but also to pursue a political agenda, a partisan political agenda, and often this is the kind of the speaker has an affirmative responsibility to help the majority to transform the political agenda into law. Of course, and it's obvious, the Speaker of the Congress of the United States is the closest president of a parliament to this particular ideal type. On the other hand, we have the so-called neutral speaker. Is elected, it could be elected by the majority of the assembly, but he is responsible not to a part of the assembly, but is responsible to the whole assembly. He doesn't have an affirmative responsibility to help the majority to legislate, but he has to guarantee that the assembly works according to the constitution. Of course, this second kind of speaker is the Speaker of the House of the most closest to this ideal type is the Speaker of the House of Commons. The essence of the role of the Common Speaker in particular is to guide and interpret the rules of the Parliament in the interest of the fairness and the moderation. The Speaker has always an historical mandate to defend the prerogatives of the Parliament from their abuses, I can say, but I mean, from the intrusion maybe, from the intrusion of Her Majesty government. And of course, there is an historical evolution of this point. But we have to consider that the Speaker of the House of Commons has a large amount of discretional power because there is there was the common sense that the Speaker is not only impartial, but is neutral. So this large amount of discretionary power should be used in a non-political way, or in a way that, or in a way under which the decision taken by the speaker are not only fair for the majority of the parliament, but also for the opposition, but in a way that the decision taken that must be perceived to be fair. This is a very important point. And the changing in this turning point during Brexit is one of the most significant evolution, or one of the most important changing in the role of the speaker. The peculiar political condition under which Brexit negotiations were led changed the position of the speaker in the UK form of government. One of the most important assumptions of the role of the House of Commons speaker is that the majority doesn't need the speaker in order to pursue the agenda, his legislative agenda. During Brexit, this concept wasn't true, because the political majority that was supporting the government wasn't the political majority or that supporting the Brexit deal. The absence of this prerequisite in order to guarantee the neutrality of the speaker was the condition that led to a politicization, a polarization of the role of the speaker during the Brexit deal negotiation. In this context, we can understand the statement of March 18, 2019 of John Bercow. That occasion became famous also in the media because the speaker quoted a very old president of the 17th century. And I think that that occasion could be considered a turning point in the tenure of the House of Commons speaker. Because after that moment, the speaker of the House of Commons wasn't perceived to be fair by the Assembly. A political observator and also member of parliament understand that the speaker of the House of Commons had his own political agenda, a clear political agenda, maybe a legitimate one, but he had a political agenda. And in that moment, the speaker, he remains with a sort of impartiality in his own activity, but it wasn't neutral. And I think that from that point, the Speaker of the House of Commons became quite closer to a Speaker of a continental Europe Assembly, like the Speaker of the Bundesrat, the Speaker of the Cámara de los Diputados in Spain, or also the Italian Speaker of Chamber of Deputies. In particular, whenever possible, each speaker decides procedural questions in accordance with previous decision, and it's clearly seen to do so. And every member of parliament has ready access to published materials in order to confute the decision of the speaker. In the statement of March 18th, in which John Bercow dismissed the possibility for the government to represent a motion in the same session, used to interpret the standing orders in a partisan way, because there are other precedents, and because there are other possible interpretations of that precedents that are closer to the point of view of the government. In the moment in which the decision of the interpretation of the standing orders of the speaker became partisan, as I said, the speaker changed his role. I think that I can give the floor to my colleague, that she will explain why the Brexit permits this changing in the role of the speaker. Then I will open to the Q&A session for any doubts.
Okay, thank you, Dr. Bargiacchi. Thank you also for being so, you have spoken 10 minutes, it was great. And I give the floor, thank you very much for keeping the time limit. And I give the floor now to Bonfanti Lidia, and so we will go on in understanding why the distress is so high at present. Please, Dr. Bonfanti, the floor is yours.
Thank you. Can you hear me?
Yours? Great.
Okay.
I can.
Thank you again. As you said before, I'm a PhD candidate at the University of Bologna in co-tutorship with the University of Antwerp in Belgium. Mm-hmm. And my PhD thesis focuses on asymmetric federalism and divided societies in a comparative perspective. And I have previously worked on Brexit concerning the constitutional status of Northern Ireland. So coming back to our presentation, my first point will be why we chose a diachronic perspective. So traditionally, the domain of comparative constitutional law did not rely on diachronic comparisons. In fact, the historical method was first limited to historians and to Roman law scholars. So looking at how legal institutions and laws have evolved throughout time was something detached from the field of comparative law. However, especially comparative constitutional law could benefit a lot from a diachronic perspective, as it would allow to better grasp the transformative effect that some process entail. In other words, looking back in time could expand our knowledge and our understanding while examining constitutional phenomena. And in the current case, concerning the British speaker, taking a diachronic perspective in the analysis of his or her role is critical to determine whether such role has changed, whether it is or can be followed by a constitutional transformation. So studying the past can help us better frame the present. So, and even if it's true that Brexit has no real precedent in history, it cannot be denied that it could be considered as a moment of constitutional distress, as every democracy periodically experiences. So indeed, Brexit put under stress one of the most ancient European democracies, undermining some of the core principles of the Westminster model. And I will take briefly into account some of the tensions arisen by Brexit in order to underline the potential for a deep constitutional transformation. First of all, I will consider the use of the referendum, which is an institution of direct democracy not accustomed to the British constitutional system. As it is well known, the supremacy of the parliament has always been at the core of the Westminster model, and the Brexit referendum was a moment in which the voice of the people was heard, and it marked a considerable shift. This is especially true in terms of sovereignty, as in the British system, it is the parliament to be sovereign and not the people. Then, even before the 2016 referendum, the theme of Brexit, so of the withdrawal from the European Union, provoked a deep fragmentation of the traditional two-party system in the UK. The Leave Remain divide crossed the party system horizontally, and this became even more evident with the 2017 snap elections, which resulted in a hung parliament. This meant that, on the one hand, prime ministers, both May and Johnson, had to rely on different kinds of majorities. The one supporting the government, which was composed of the Conservatives, plus 10 MPs from the Democratic Unionist Party, and other kinds of majorities on the Brexit matters, which were cross-party. Another consequence of the hung parliament was concerned the role of the speaker, as there was no clear dynamic between the majority and the opposition, and so the speaker had to play a more a prominent role. Perhaps the most meaningful aspect is the relationship between the government and the parliament. In fact, along the Brexit process, there were many instances that put under discussion the traditional relationship between Downing Street and Westminster. For example, in 2018, there was a unique case of motion of contempt moved and passed against the executive. In that case, the May government wanted to push the parliament to vote the withdrawal agreement without having first published the integral version of the legal advice on the Brexit deal. Another episode was the already recalled legal precedent of 1604. As in 1604, the executive wanted to compress the role of the parliament, pushing its agenda, but the speaker in both cases decided to limit the role, counter-limit the role of the executive, reaffirming the role of the parliament. So the balance between the two constitutional bodies became especially evident with the renowned decision of the UK Supreme Court on the prorogation of the parliament. In that case, the advice of the executive to call for the prorogation of the parliament was declared illegitimate and therefore null and void in its effect. In fact, the power of the Prime Minister to advise the sovereign to announce the prorogation was considered limited by two constitutional principles: the sovereignty of the Parliament and the responsibility of the executive towards the Parliament. This meant that the dominance of the government, which is a traditional aspect of the Westminster model, cannot question the sovereignty of the Parliament. The Parliament seemed to have acquired an even greater role throughout the Brexit process, even more than the government would have expected and probably would have wanted. So in this context, the transformative role of the British speaker, which Stefano was referring to, fits perfectly with this process of constitutional transformation. Its activism, in fact, recalls for a more continental model of parliamentary democracy rather than the traditional British one. However, it should be reminded that it is necessary to keep observing the future role of the speaker in the coming years in order to assess if the transformation was only temporarily linked to the Brexit process or whether it will be more permanent, becoming part of a new Westminster model. Besides, if we take a wider diachronic perspective, we may observe that a process of constitutional transformation of the British system was already in place. In fact, since 1997, a series of constitutional reforms was enacted, moving the Westminster model further away from its ideal typical form. Without any doubt, Brexit was the most spectacular turning point along the British constitutional history, but it would be mistaken to affirm that it was the only trigger of this constitutional transformation. On this respect, a final point that could be interesting to make is the role of parliamentary procedures in shaping the form of government, and thus in the overall process of constitutional transformation. In fact, in a parliamentary system traditionally dominated by the executive, parliamentary procedures reframed the centrality of the parliament, especially in a condition in which the executive was not as solid as it is in the norm. However, and moreover, the parliamentary procedures and the role exercised by the speaker compensated the absence of a written constitution and guaranteed the functioning of the UK constitutional system in a moment of constitutional distress, such as Brexit. So in conclusion, it is not possible to predict the future, stating that the role of the Speaker of the House of Commons has forever changed. But we can say that it cannot be excluded a priori that the Speaker may play once again a more active role in the next phase, in a potential next phase of constitutional stress. In fact, even if Brexit is and will be a unique phenomenon in British history, another crisis might come and the Brexit and the Speaker might need to take a prominent stand to preserve the role of the Parliament.
So thank you very much. Great picture of what is going on right now there in Great Britain. And now I open the question and answer session, and just raise your hands and put questions to our excellent speakers, or simply unmute your microphone and ask if something is, some question is present.
Can I?
Sure.
I have one question to Bargiacchi. Bargiacchi said that the decision by the Speaker of the House, Bercow, in refusing to have a certain motion voted again was seen as breaking a tradition and moving the Speaker of the House from sort of his neutral position to a partisan position. However, I'm somewhat of this. I mean, although I mean, we know the Speaker of the House for his very colorful ties and a very colorful speech. However, I fail to understand why Bargiacchi sees in this decision some kind of change of attitude. I mean, this is the fact that you cannot represent a motion that has been rejected is a basic principle of any assembly. I just would like to recall, I mean, because it's, I mean, it's the handbook of parliamentary procedure. Erskine May on parliamentary practice, which is you just go on the House of Commons and you find it there. And very simply, Erskine May, and this Erskine May is a 19th century author. The same question or bill may not be twice offered in a session unless it is substantially changed. And this is the, at least this is tradition. I mean, just to make it, see it from a comparative point of view, if you look at Ugo Galeotti in Il Manuale, sorry, I sort of, as I sort of been, when I was a young boy, I worked there, Principi Regolatori delle Assemblee. Well, obviously, this is a principle that you find not only in the, obviously in the UK Parliament, in British Parliament, but also in other parliaments. So my question is, why is this seen as, I mean, reaffirming a principle, a general principle of this, how assembly should work? Why is it seen as a shift in the position of the Speaker of the House of Commons?
Thank you for the question. I think that two considerations on these remarks can be made. The first one is not only the decision itself, but also the context in which the decision was taken. In particular, in a context in which the government pushes a lot of energy and a lot of effort to obtain this kind of decision, another meaningful vote on a text in which, according to the opinion of the government, a new majority would be reached, the decision of the Speaker destroyed basically the strategy of the government. Of course, and if we use the point of view of the Speaker, and it could be the correct point of view probably, the decision of the Speaker doesn't have to take in account the strategy of the government, and basically the decision of the speaker are taken in order to preserve, to defend the prerogative of the houses. On the other hand, the principle of ne bis in idem, no, to avoid a double deliberation of the same object, also in the House of Commons parliamentary tradition, had in the past some exception. And in that context, the government asked, or the parliament that are closer to the position of the government, asked or opted for an interpretation of parliamentary law that maybe could be based on some quite unique, but anyway present precedents of the House of Commons. The speech is, I think, it's also a turning point, because in the past, from basically from the starting of Brexit deal parliamentary approval process, the parliamentary law became a quite mainstream topic of the House, and also of the media debate. But until that moment, the Speaker of the House of Commons wasn't perceived a political actor. After that moment, everyone, and I don't know if it's I mean, because maybe some journalists are quite skilled or not, but after that moment, anyone could tell John Bercow is a not Brexit, not Brexit deal supporter. So I think that the context and the fact that there are some possible interpretation of that principle that could support the will of the government, and that John Bercow decided explicitly to deny that possible interpretation. But with regard that the fact the interpretation given by John Bercow was quite a condivisible interpretation of parliamentary law.
Okay. Other questions? Q&A is always closed. So this discussion reminds me to another book which can be interesting for comparing different situations with the Brexit one, which is the book of Miriam Iacometti, on the presidents of parliamentary assemblies. There you can find, of course, that has been for sure the basis for your research, but it is worth recalling that she worked very, very, very deeply on the subject, on that subject. So it might be used to have a discussion with her, even if you like coming to Milano and visit us.
Yeah, of course.
when the lockdown will be definitely closed.
Yeah, it
would be a pleasure.
Yeah, it would be a pleasure to come.
For sure, we can organize it once we will be out of this terrible part. And indeed, we are still working in Milano. I don't know how it's working in other universities, and discussing on how we will address the September semester. Still don't know what's going on indeed. So, no other questions? Okay, then let's go on in our session. And now it's the turn of Gürkan Karpar.
Yes, I'm here.
Okay. Hello, welcome to our session. Well, thank you for having given your paper, your abstract. Why government checklist lists do not work. And so please again say something about your CV up to now, and then go on with your presentation. Okay.
Thank you, Professor. First of all, I would like to thank everyone for having me here. My name is Gürkan ÇAPAR. I'm from Turkey. I'm an LLM student in legal theory at Goethe University. However, I am also deeply interested in comparative constitutional law. Also, I have a presentation. I want to share my screen as well.
Can you make it? Okay. Yes, we see why governance checklists do not work. Okay.
Okay.
Now it's fine. Okay.
Okay, indeed, this is the question which is asked by Kim-Lane Chappell in her famous article. Indeed, it is in this article, Kim-Lane Chappell argues that private virtues may lead to public vices. She argues that governance-led checklists do not work because they did not take into account the interaction effect of private components. That's why at the end of it, a Frankenstein come into existence. That's why devil is in the interactions, and if the devil is in the interactions, then we need new ways of seeing new methodologies to grasp that reality. And I think that legal theory can prove useful to this endeavor, and especially Hart's internal and external point of views may be extremely useful in that work. My main research question in this presentation will be why the most prominent scholars in Turkey fail to see the fact that the 2010 constitutional amendment, which drastically altered the composition of constitutional court, was indeed a constitutional capture. Unlike Poland and Hungary, in which there is a shared consensus about scholars as what's going on and about the attacks of popular governments to the courts. Indeed, it's of course a constitutional court capture, but in Turkey it is not like that. Lots of scholars even argued that indeed this is a progressive movement, this is a democratization movement. For example, Aslı Bali argues that the realistic assessment of the meaning of the constitutional referendum was not enough, but yes, they want even more. For example, lots of scholars just appeal to the reports of Venice Commission or the Consultative Council of European Judges, or to also some scholars again argue that if the judges are elected by parliaments in Italy, Spain, France, and etc., why not in Turkey? Also, some scholars, I think the first three scholars I just mentioned, embrace internal point of view. They are just so much inside the legal tradition of their own country. But when it comes to other scholars, for example, Albert, Olcay, and Nakajitze in their article in 2018 argues that the change, of course, the constitution, after the 2010 amendments, constitutional court changed its precedence drastically. For example, before 2010, the court just put into use the unconstitutional constitutional amendment doctrine in 2008. However, in 2016, the court just shy away from using the unconstitutional constitutional amendment doctrine. And some scholars argue that it is indeed a formal resistance. Of course it is not. It is a constitutional capture. And this is my argument that if we just could not embrace a correct, at least a sophisticated point of view, we cannot understand what is going on in this context. As I said, for me, there are two different sides. One of them extremely internal point, one of them embrace extremely internal point of view. The others embrace extremely external point of view. It is my argument that we have to embrace a harmonetical point of view. Indeed, this is the point of view of Weberian tradition. Weber tried to strike a balance between, how Weber tried to strike a balance between two different traditions. I think that we could follow a similar path to Weberian way, between a crude textualism or between a deep radical contextualism. My presentation will follow generally this guideline. In the first part, I will just focus briefly the paradigms in social science, internal and external point of views, in comparative law and legal theory. And I will try to address the question of how a comparativist should compare. Later in the second part, I will just look at the 2010 constitutional amendment in Turkey, and I will just show how internalists or externalists fail to take into account lots of things. However, there are some, of course, others. These are embracing harmonical point of view, at least for me, that could achieve at least to describe what is going on in Turkey. Indeed, there are two different paradigms. This is very crude. On the one side, there are positivists. On the other side, there are interpretivists. And it is my argument that we have to follow this middle path. I think this is the path of Weber. And also, comparative law is so much related to about understanding each legal system on its own terms. That's why I think that at bottom, every comparison begins with understanding. Okay, this is a similar thing. We can also see paradigms in also in comparative laws, textualism, contextualism, etc. These are obvious. Also, I think that recently there are some scholars try to establish a connection between comparative methodology of comparative law and legal theory. I think it begins with Ewolds, and Ewolds just argues that we have to understand law from inside. Also, Walke recently argues that any form of legal comparison cannot but engage the commonality as well as specificity. Indeed, commonality stands for positivist paradigm, specificity stands for interpretivist paradigm. Again, the same arguments indeed. It is this phrase, I think, perfectly captures what we are trying to do. Not to surrender to otherness, but explain how understanding is possible despite otherness. And we can just see that no need to be Caesar to understand Caesar. I think this is the phrase of indeed George Simmel, and Weber also pursued this path. No need to be a Turkish or Italian to understand what is going on. Italian, we can still capture something, what's going in there, but it is required, of course, the correct methodology, and it is interpretation. I'm just passing these parts. Also, in legal theory, there is a general distinction between external and internal point of view. Hart is the first scholar that introduced this distinction. Later on, McCormick argues that there is also a third position. Indeed, this is the position of Hart. This is the position of Weber for me. The third way, indeed. On the one side, there are natural scientists externally observe the phenomena and doesn't take into account some specificities or particularities. On the other side, there are internals. These are extremely internal ones. For example, we can just remember Winch's internalism. And between these two sides, there are also the position of legal scientists or comparatists. Try to understand what's going on inside a legal culture, but also attempt to preserve its scientific endeavors. Also, Hart explicitly points out that the purpose of jurisprudence is to understand how legal agents see and act within the law. Okay, I call this the third way as hermeneutical point of view, and it also has ethical dimension for me because it respects for the authenticity of people's thinkings and doings. We take into account how people understand what is going on and how people understand law, and that's why it has also some ethical dimensions. We just don't impose our own preferences or frameworks to understand the inside of law. When it comes to Turkish Constitutional Court and its context, first of all, I just want to briefly summarize what kind of a court was the Turkish Constitutional Court was once. First of all, this court was one of the most activist courts maybe in the world because it was the first court that deploys the unconstitutional constitutional amendment doctrine in Europe. Indeed, the first 4 cases that used unconstitutional constitutional amendment doctrine in Europe was from Turkey. Closed 18 political parties in a decade during 1990s. The perfect example of militant democracy. However, after 2010 amendment, the court changed her precedent radically. Especially, we can just observe it unconstitutional constitutional amendment doctrine, and also we can observe it in emergency degrees that the court changed her precedent drastically. Also, it's a question: was it really a court packing? Of course, it may be argued, but my main argument based upon on that. And I think that we can just draw on Dixon and Landau's article about abusive judicial review. In this article, Dixon and Landau argues that if there were a drastic shift or change in the precedent, we can assume that it was indeed a court packing. The constitutional, when it comes to 2010 constitutional amendment, it comprises of 26 articles. 9 of them was related to judiciary, 7 of them related to fundamental rights. As it's obvious, the crux of the amendment indeed has to do with judiciary. The composition of the Constitutional Court changed from 15 judges to 17 judges. Indeed, before amendment, there were 15 permanent and 4 alternate judges. It changed 17, and the pool of the judges expanded, and it gave incumbent government more chance to pack the court indeed. Also, before the amendment, there were no term of office. However, after the amendment, 12 years term of office included. Also, there was drastic changes in the composition of the Supreme Council of Prosecutors and Judges. This council assign the high judges to the high courts. That's why it is also very important. When we just look at the background of the amendment, indeed, the amendment is the consequence of a political backlash, because in 2007 and 8, there was a constitutional crisis in Turkey. We can just see 3 important decisions. I think you may all know, but one of them is the infamous headscarf decision that the court used unconstitutional constitutional amendment doctrine in a very wrong way. Here comes my main arguments here. When we just look at some scholars, I think these scholars or these arguments comes from very extremely internal point of view. And the reason of that is because during 1990s and 2000s, there was a predominant discourse in Turkey, and it was that the Turkish Constitutional Court is a representative or representation of hegemonic preservation thesis of Hirsch. According to this thesis, Turkish Constitutional Court, rather than preserving constitution or preserving democracy, preserve some interest of some elites. That's why there is a bad idea about the Turkish Constitutional Court at that time. We can just see it from the names of the articles that written at that time. And also some scholars explicitly say that the court was conceived as an instrument that will protect the fundamental values and interests of the state elites. Also, in 2010, the main concern for democracy is to reform the judiciary. Judges was indeed some kind of a threat to the democracy in that time. For example, Bali argues that the 2010 amendment indeed is an attempt to unpack already packed court by democratizing judiciary. Also, this amendment reformed some of the most illiberal provisions. It was judicial reforms indeed. And she also explicitly argues that the amendments hardly amount to court packing. Also, we can see that these scholars appeal to the reports of Venice Commission explicitly. Also, Venice Commission evaluated these constitutional reform as a step in the right direction in the ongoing process towards the modernization of Turkish constitution. It is my contention that these Venice Commission positions correspond to the external point of view, because Venice Commission did not take into account the interactions between these private components. When it comes to external point of view, outsiders, for example, in this article, these authors argue that in somewhat of a surprise, the court has recently returned to its pre-2008 judgments. Indeed, it is not a surprise, because in 2010, there is a drastic constitutional change and the court was packed, and that's why it is impossible for court to use its previous judgments again. Also, for example, I think this is also another wrong argument. For example, Bali argues that the best argument for judicial review is the protection of individual rights and minorities. I think it is explicitly a US-oriented point of view, US-based point of view, because in continental tradition in Turkey, There are lots of other reasons. For example, protection of separation of powers is also a very good reason for judicial review. And lastly, I came to the hermeneutical point of view. This is the point of view that, at least I think it is more, they approach more in a more nuanced way and more sophisticated way to understand what is going on at that time. And they explicitly say that it's an attempt of court packing. For example, Varol argues that the added 6 new seats to the court indeed gave the power to appoint all 6 justices to the political branches. If we just look at it, before the amendment, we see 11 judges assigned by president, but president assigned these judges from a pool of judiciaries, for example, or government-friendly institutions. Before amendment, there was a superiority of judiciary, 6-5, but after the amendment, it drastically changed. And of course, if you just look at this picture, it's obvious that not in a long term, in a short term, the court will be packed. Also, Arato explicitly, I think this is really illuminating. Arato argues that it is the Turkish Constitutional Court is not an example of juristocracy, but the establishment of at least one check and balance in an increasingly monolithic system desperately in need of it. Those Democrats, I think these are Bali or Özgür'ün, who in that context attacked the court for historically understandable reasons, were nevertheless fighting the battle of yesterday. Yes, the battle was for yesterday, but they failed to capture the essence to see the very possible, if not inevitable dangers of tomorrow. Also, we can see in 2010, Arato explicitly stated that the main argument of Kimlen-Chappell, indeed, the Frankenstein argument. What may be good and fair in one democratic setting may be unfair and authoritarian in another. One could indeed put together quite an authoritarian system by choosing some particular mix of regulation from various liberal democratic states. There are also other arguments, but
listen, Gürkan, you have 3 minutes left, so try to summarize get to your conclusion. Thank you.
I'm almost done. I think the Turkish example may be a single case in history, but I think that it may illuminate or shed light on the fact that methodology has utmost importance to understand what's going on or the reality. Because where we stand indeed determines what kind of knowledge we will acquire or build or construct. As we saw, both insiders and outsiders fall short of capturing the 2010 constitutional amendment holistically. However, there is a tertium datur, a third way. I think this is the Weberian way, to see the facts in a more sophisticated and nuanced way. This is the, as I said, Weberian way. It is more compelling and more meandering way, yet it has the capacity to address the threats posed by abuse of constitutionalism. Thank you for all listening to me. Thank you.
Thank you. Thank you very much. It was a very bright view on the Turkish experience, which is, of course, very bothering for everybody. And now I open to questions. We are jumping from UK, Turkish, and US, so this is the goods and bads of comparing different situations. So it might be possible that somebody is still thinking. Okay, we can also, just in case, have answers after other papers.
I'm sorry.
Okay.
KAZAI and Professor Passaglia, if you keep an eye on the screen and on the panelist list, you see who's asking to speak.
But listen, just a question. If I click to question and answers, there is no one asking for the word.
If you look at participants, sorry, Lorenza, look at participants, click on participants.
Participants, okay, fine.
And you see panelists and attendees. And
panelists and attendees, that's the difference, so yes. And now I see panelists.
There's Passaglia and KAZAI who would like to intervene, sorry.
Well,
Passaglia has raised his hand and KAZAI has raised his hand. in video, and so.
Okay. I already sent in video, but I don't see them. Okay, so the word to Passaglia. I give the floor to Passaglia for his question.
Thank you.
Paolo?
Thank you. It is not really a question, just some reflections on what I heard, and I thank you for your presentation. It was very interesting. I think that the Turkish Constitutional Court is simply a constitutional court that is a specialized body of constitutional adjudication that requires to be handled with care, and any court can be packaged. For instance, the Italian Constitutional Court could be packaged quite easily if the parliament did not appoint 5 of its members, and the court would be obliged to not to deliver judgments, because to deliver judgments 11 judges are needed, and the court has 15 judges, and 5 out of them are appointed by the parliament. So it is very easy for any political power to oblige the Constitutional Court not to be active. So I think that what happened in Turkey was not, it was difficult to understand simply because we are lawyers, we are not political theorists. And when the political landscape changes, we don't have instruments to understand the old system. We can look at a part of the system, but the other part is out of our reach. Simply that reflection I would like to share with you. Thank you.
Thank you, Paolo. Would you like to add something, Gürkan?
No, I'm totally agree with Professor. Constitutional courts are political actors, for me at least. Okay.
Okay, so Viktor, KAZAI, it's up to you.
Thank you very much. I just wanted to share an article with you. I'm sending it in the chat. It's from Renata, who it's actually, she happens to be my supervisor as well. Because this is more or less what happened in Hungary as well after 2010. The very first decision of the Hungarian government was to back and to curb the Constitutional Court. It was the smartest decision of the governing majority, because now we have the Constitutional Court whose wings are clipped, and they are unable to, and unwilling as well, to exercise any sort of meaningful control over the government. And this article that I share with you, this is exactly about the methodological difficulties of comparative constitutional law, how to grasp these phenomena, which seem to be only political, but in fact are deeply constitutional problems. So I don't want to elaborate on that. Everything is in the article. I just thought that it's interesting to share with you.
Yes. Thank you. Thank you very much. And now, let me have a look. We have a couple of minutes for another question or remark. Viktor? Well, if not, then I think we can go on with our panelist, Ángel, Aday. So thank you, Gürkan, for your presentation, and we will keep in touch. Okay, Ángel Aday JIMÉNEZ Aleno from Spain.
Thank you very much, Professor.
Hello. So you will also give us some information about your CV, but let me say in advance that your paper is very interesting. We are jumping again in another country like Spain, but your methodological approach is very interesting. So not only in general comparison between courts, but specifically how a single court has influenced another constitutional court. So congratulations for your approach, and the floor is yours.
Thank you very much, Professor VIOLINI. And just double checking that I think everyone is listening to me. And thank you as well to all the members of the organizing committee for giving me this opportunity to share my work. And I'm going to give you also give a little background about myself. I'm a lecturer of constitutional law in the University of Vigo in Galicia, Spain. And actually, this presentation is based on a previous work it was a contribution to a collective work directed by Professor Ferrari, who is in the audience, and is also my current line of work, because I have checked during these last 2 years that this very global trending topic and hot topic about the influence and the uses and abuses of foreign law by constitutional and high courts, at least in Spain, in our scholarship, it hasn't been so studied or so analyzed, and also by international scholars. Usually, Spain is not on the focus. So what I am trying to do is to now to write a monography, honestly thinking in the Spanish audience, but perhaps as well to try to engage with the this general debate about this topic. So what I decided to focus in this case, in this presentation, on this influence between the US Supreme Court and the Spanish Constitutional Court, is mainly because it allows me not only to give you the usual empirical data that I'm going to do it, of course, but also to try to do a qualitative analysis of the cases where the Spanish Constitutional Court have used the case law of the US Supreme Court. So, as I was saying, we didn't have so far, I think, a public debate so important as we saw in the United States between the judges, the famous debate between the judges Scalia and Breyer. But we are, I think, starting to see in Spain, at least in the judgment of the Spanish Constitutional Court, at least in two separate opinions, some kind of resistance to the use of foreign law. But I am referring to Andrés Ollero separate opinion to the famous, at least in Spain, judgment in relation to the same-sex legal marriage, 198 of 2012. And also in a more recent judgment by Professor Balaguer about the separate schooling in Spain. So you can see that it's well known that both of them are from different ideologies. One is more a conservative ideology, the other one is a progressive ideology. This is publicly known. And you can see that at least in these two cases, both of them criticizes the use of the foreign law by the Spanish Constitutional Court. So I think that the debate is open. And surprisingly enough, you can see the presence of foreign law and also of decisions from foreign constitutional supreme courts in the Spanish Constitutional Court, more or less in 2-3 decisions judgment every year since the very beginning. For example, just the fourth judgment of the court, it has some references to the German Constitutional Court and the Italian Constitutional Court. It was about the local entities, the powers of the local entities in Spain, but the real issue here was if the Spanish Constitutional Court has power to review statutes passed before the Spanish Constitution, and here the Spanish Constitutional Court uses as authority the previous decisions done by the Italian Constitutional Court and the German Constitutional Court. Also, one thing to have in mind, I think, is that we can find references to foreign comparative law in any part of the judgment. It's not only that you can see in the facts when the court is summarizing the points of the different parts, but it has been doing even the Constitutional Court in the legal ground uses it to support its decisions, as we are going to see. And so here what we can see is perhaps the usual debate about the proper use of the foreign authorities, and even if we can accuse the Spanish Constitutional Court of some kind of argument, deus ex machina, to support its weak arguments in some cases. Okay, so in this case, I decided to base this presentation in the case of the U.S. Supreme Court because it's not the usual suspect. Obviously, it is well known that the Spanish constitutional law is not the most original thing, and in our case, perhaps the most original contribution, the status of autonomy, it has been working for 30 years, but at this moment, perhaps it's not working so good as before. So obviously the Spanish Constitutional Court followed the German and the Italian model, and also our scholarship has been really influenced about by the German and the Italian scholarship. But it's not the case that it has been a reference. We cannot say that it has been a reference, the American or the United States scholarship in our case. I am saying that it's normal to say that the German and the Italian constitutional courts are going to be there as usual suspect, but obviously it's an influential court, the American one, but it's not in our legal tradition, and it's not part of our European culture. So I thought that it could be interesting to focus in these cases. So at least you can find more than 100 references during these 40 years of case law from the Spanish Constitutional Court, and at least 40 of them are references to decisions from the highest court from other legal systems. As it usually happens, this is a general trend. Most of them are related to fundamental rights, in this kind of Alexis' point about the open nature of the fundamental rights articles in our constitution. And here is just some background as well, is we must to bear in mind that the Spanish Constitutional Court is one of the courts that resorts explicitly to comparative law, but just in few occasions. In this sense, is following the trend of the German or the Austrian Constitutional Court, and also even from the Supreme Court of the United States. But as I am saying, so far it has been something peacefully, I think, accepted by at least by the scholarship, going beyond of these two separate opinions that I comment you at the beginning of my presentation. So to give you some more empirical data, when you go to our case law, you are going to find that the Supreme Court of the United States is the court most quoted, most cited in general. I have found 37 references, followed by the German Federal Constitutional Court, 34, and in this case, the next one will be the Italian Constitutional Court, 27. But if we go to the legal grounds, where the Constitutional Court is using to enrich or to support the arguments, we are going to see that in this case, we have 15 references to decisions of the German Federal Constitutional Court. And next goes, there is a deuce between the Italian Constitutional Court and the Supreme Court of the United States with 8 references. So This was quite a little bit shocking for me, in the sense that it is very common for lawyers and legal scholars in Spain to go to Germany and obviously to Italy to pursue our studies, and it's obviously the public law scholarship is from these two countries a reference for us. But something that perhaps is changing during this last decade, but it's not so common to see lawyers in Spain educated in the United States. For example, if we go to the Spanish Constitutional Court justices and even to its law clerks, I don't know so many cases of justices and law clerks educated in Spain. There are a few cases, but compared to lawyers educated in Germany and in Italy, they are just a minority. But in any case, we are going to find those 8 references to the U.S. Supreme Court in this kind of influence and kudos that the United Supreme Court has over globally, in just a few words. So here I am going to focus in these cases, and especially in the uses or abuses that the Spanish Constitutional Court has done so far. So we have one reference in the judgment 232 from 1983. The case, it was related to fundamental rights. It was about the information policy by a media company about the statements of a third party that violated the fundamental right to honor, if that could constitute a violation of that fundamental right as well, again. And here this is an interesting case for this presentation because the Spanish Constitutional Court quoted New York Times versus Sullivan, and it takes the reference of the change in this case law about the neutral reportage, about the neutral report. And here the interesting thing as well is that there is a kind of dialogue or conversation about that case specifically between the claimant and the Spanish Constitutional Court. And the Spanish Constitutional Court agree that it has been a groundbreaking change in the United States case law in that term. So in this kind of uses, like to ease a better understanding, I think it is a proper use. So there shouldn't be an issue here. Also, we can find examples when the Spanish Constitutional Court uses it just to contextualize. There was a more or less recent case in 2016, the 140 judgment. This was an statute that was passed during the financial turmoil in Spain, and that established a tax to claim in courts in Spain. So the Spanish Constitutional Court recognized that this can be understood as some kind of chilling effect, that has a chilling effect. And it said as well, literally, that this doctrine came up from Beeman and Abdesgraft in a US Supreme Court case from 1952. Also, I think that this could be widely accepted without any problem, that it could be proper to use it to establish distinction when they are interpreting. And we find an example in judgment 127 in 2000, sorry. This was as well a claim for the protection of fundamental rights, and in this case was a person convicted for collaborating with an art group. And here the Spanish Constitutional Court established some kind of distinction with a US Supreme Court precedent in a Miranda versus Arizona, saying that the Spanish case was different because it was not a matter of police interrogation without the presence of a lawyer. So another good example of interesting use and a proper use. We have it as well in 2013 in 199 judgment. In this case, I think that it's perfectly seen that it was just used to improve the interpretation. But I must recall that perhaps there is a conflict of interest here because I participated in some way in the previous work of to draft this judgment, because I was working at that moment in the Constitutional Court with a scholarship in the Spanish Constitutional Law Case Law Department. And in this case, they asked us to provide with a translation from this case from Maryland versus King. I remember that in the Spanish Constitutional Court, they were very worried about the proper use of DNA in criminal prosecutions. And in this case, we have a very good reference in Maryland versus King. So here so far, I think the proper uses. So let's go for the abuses. And the main abuses that they have found, I think most of them that what we can do is it is easy to accuse the Spanish Constitutional Court of just using the references, and especially these references to the US Supreme Court, and taking advantage of their feudos just to support the conclusions that we can suspect that were previously reached. For example, in Judgment 140 from 1984, here we have a dismiss of an appeal for a protection in relation to a redundancy procedure based on the recording of a phone conversation without the appellant knowledge. And here the court quoted literally United States versus JIMÉNEZ from 1976. And this is something that I recognize that I have to look more and continue working, because I think that in the use of the judgment this quote is quite partial, and they are taking what they really wanted to take from that judgment and not giving the whole context. But I know that it's from 1984, so it wasn't at that moment so easy as is nowadays to access and to follow case law from other court and constitutional court. But I have that suspicion that I recognize that I must double check. Another case in this sense that we can have the sense of a previous decision done is it the case in the judgment 127 from 1994. This was in relation to the coming of private television broadcasting to Spain. And obviously the Spanish government and the Spanish parliament regulated that. And there were some cases related to this regulation as a limitation of fundamental rights in Spain. And here we found, again, two references to Red Lion Broadcasting and Columbia Broadcasting System versus the Democratic National Committee, cases from 1969. Where the Spanish Constitutional Court support its argument about that this kind of license can be a privilege. So it's something that must be regulated by the parliament, and we cannot say that regulation just only for being a regulation goes against fundamental rights, the freedom of expression, and so on. And there is another case as well in 1987 about the use of retroactive tax rules, and I'm going to focus on that due to the time. But I am going to focus in just last one that is quite recent and is quite important because it's a hot topic still, the separate schooling. And here again, usually you can say that these kind of arguments are used to support progressive ideas. I think this is a common understanding, but here we are going to find a use to support a conservative idea in the sense of that here the Spanish Constitutional Court supported itself in United States versus Virginia, a case from 1996, and also in the two cases from Belgium and from Germany, saying that separated school necessarily doesn't go against the protection of equality. They are saying that you must go more and to go deeper in that question to see if the regulation is not giving enough opportunities of equality. But the idea of having separated schooling is according to the Spanish Constitutional Court and the protection of equality, and also in our case that we have the recognition as well of the protection of the material equality in Article 9, not only the protection.
I hate to interrupt you, Alice, but your time is over. So
oh, sorry.
If you want
just to conclude. Sorry, just to conclude.
No, it's okay. It's okay. It's my work to keep.
Just to insist that we can see that not always the Spanish Constitutional Court is using the foreign law in a dialogical mode, that I think it will be the proper use, using Chaudhry terms, and that most of the times is quite difficult not to criticize the Spanish Constitutional Court for using some kind of theological conscience and to support a previous reached decision. Thank you very much for your time. I'm sorry.
No, thank you. Thank you. Most welcome to give us a lot of examples, very concrete. So now, panelists, let me be, and I don't see, I see 3 hands, the blue hands. Okay, so again, KAZAI, Viktor, you're welcome to put your question if you prefer, then Somma, and then Vincenzo.
No, sorry, it was for the previous presentation.
Was the previous question? Yeah. Okay, great. Then it's Alessandro Somma, Professor Somma.
Okay. Thank you. Thank you for this presentation. Quantitative data are always important to have a more complete insight into problems. I wonder if you also can give us a sort of qualitative evaluation, for example, from 2 points of view. I can imagine you have always found examples of use of comparative law, which we could name constructive uses. That is, I pick up an example from another national law in order to move my national legal system in the same direction. But I can remember there are very, very few cases, for example, in Italy, but also in other countries, where we have a destructive use of comparative law. That is, I pick up an example from a foreign legal system in order to show that this system shares values I do not share, so that I have to save my identity and choose a completely different solution than the one which has been chosen by the other legal system. That would be the first curiosity. Did you also find examples of destructive use of comparative law? And the second problem to me is of course, we are talking about a use of comparative law which is not compulsory, that is a rhetorical use of comparative law. But anyway, we can say that in some cases, this is an important use, that is an argument which is really leading to a specific conclusion. But there are also situations where the judges just want to show their knowledge in comparative law, and one can understand that the comparative law argument plays no role in the decision, even from a rhetorical point of view. So I would like you to give us some insights also in this qualitative part. Thank you.
Thank you very much, Professor Soma, for your two comments. And going to the qualitative analysis, sorry that I didn't focus in the presentation. Sorry. So in that sense, what I have seen is that it has been very common, as you are saying, in our case, in the separate opinions. It is, and in this case, is when you can check that when the justice came from the academia, is quite common to see this kind of uses. Just in some way, we can say that it's just bragging about the previous knowledge in constitutional court. And this is what also in relation to the first comment, it what worries me, because I think that after following all the debate in other jurisdictions about the proper use of comparative law, and I agree that it could be a proper tool if it is used in a wise way, and that is something that we cannot avoid. That, and there is in general is the debate about the proper use of comparative law. So in this sense, what worries me is to perhaps to contribute with methodological tools to support this work. And for example, this is quite common in common law countries, and you can check that in the courts always there is some kind, not a specific department, but they have a little team who is following this. And also in Europe we have the Venice Commission, that it can be very useful in this sense. But I have seen that I think that in the Spanish Constitutional Court is something done in a more I'm not going to say in a superficial way, but it's just something that is directly done by the justices and by the law clerks. So I think that, and the other thing that worries me in terms of transparency and rule of law and democracy, and also taking account that our constitution that literally says in Article 120 that courts obviously must give the reason of their arguments. I agree with the use of comparative law and free law, but it's something that must be reflected, at least in the judgment. How was the process of reaching that conclusion? In this case, there were comparative law used to reach that conclusions. Okay, just say it and say what was taken into account, because it's part of the argument. And for example, in cases, this is something that perhaps you can confirm me, that for example, in Italy and in France as well, in both the Conseil de Constitutionalité and the Italian Constitutional Court, when there has been materials from another countries used for drafting that decision, they are published as well with the judgment in the website of the Constitutional Court. So in this, with this kind of methodological support, I think that it could help perhaps to go beyond the criticisms. Obviously, there is the question of the constitution, of the democratic base of the constitution. In Smithsonian terms, the constitution is the most important decision of the people of a country, and that in that sense related to constitutional identity. But in any case, I think it's a tool unavoidable. So let's go for supporting with methodological elements of that tool.
Okay, now Vincenzo, did you raise your hand?
Yes, very briefly. First, obviously, I imagine that JIMÉNEZ ALEMÁN will always keep in mind Antonin Scalia's dictum of cherry picking, and this is very true. The second point, I think that it's important, especially for young scholars that engage in this topic, to keep in mind what the very thoughtful remarks of Giuseppe Vergottini he made on the issue of so-called quote-unquote dialogue. And finally, the last comment I wanted to say, in your title you use transatlantic dialogue, but that is not dialogue, it's simply importation. the US Supreme Court, apart from that very rare case of Roper versus Simmons, doesn't look at anything else. It looks a little bit in the common law, in the English courts and Australian courts, but really there's no dialogue. So, I mean, I would refer that to the very striking remarks of Maurizio Lupoi, who says that there's no dialogue with the US. It's simply, we import from the US, but the US does not import anything from our continental European system. Just to point out that when you use dialogue, I think maybe dialogue is reception, I feel, is a more correct, from a comparative point of view, terminology is more correct. Reception of or circulation of models, of ideas, and so on, but not dialogue. That's all, the only thing I wanted to say.
Sì, Paolo? Paolo Passaglia?
Thank you, Lorenza. Thank you for your presentation. Just a question. I was very surprised by the use of the Spanish Constitutional Court of the U.S. Supreme Court judgment, because looking at the case law of the Italian Constitutional Court in the last 2 decades, references, of course, references to foreign law in the Italian court is not so, are not, at least totally not more than 50 in 2 decades. But among these 50, I think that because the U.S. the U.S. legal system, not Supreme Court, but legal system, has a couple of references or 3, whereas most of the references are to Germany or France or United Kingdom, and especially to Germany and to the Bundesverfassungsgericht. That leads me to think that a key issue in deciding where to search the cherry is the European Union and the integration among legal systems that is a means to help comparison between the legal systems, and that excludes a little bit the Supreme Court, the U.S. Supreme Court. The second question was, did you find some differences, some changes among before and after the Catalan statute judgment and the crisis concerning constitutional court's legitimacy? In other words, has comparative law played a role in strengthening the court's legitimacy? Thank you.
Thank you. Sorry, Professor VIOLINI. Thank you very much for the 3 very relevant remarks. Going first with the remark by Professor Zenos and Coach. Just to say that I completely agree with him about the improper use of dialect. I just couldn't avoid the use of the catchy word in this time, but I promise him that in the book that I'm writing now, the first section is about that is not a correct use of the word dialogue, but it has been as well in Spain a very catchy word in the scholarship, and perhaps in some way I am not looking for a scapegoat, but it's in some way the fault is about Bergottini, because in Spain his work has been as well very famous, and what I am trying in some way to do is to promote the second half of his famous book, from at least it was published in Spain in 2011, and the first one is based on the European legal system in general, and in the other one of the authoritative influence of the foreign law in this case. So what I'm trying is to promote the second half of the Bergottini's work. And with Paulo remarked, the 2 very relevant, and in some way related to Bergottini's work as well, because I'm using one of his contributions in the saying that perhaps one of the most important things to build or elaborate some kind of map of recognition. I think he used that words to say what are the constitutional curves that in some way we are sharing the same legal culture, the same values, so they can be quoted and used. And that for me, I think that obviously we can take the reference from international curves when we are setting international conventions, but we should in Europe focus more in the constitutional curve for the 27 countries of the European Union, because we are sharing this progressive union, the construction of this European project. And perhaps it could be a way of not only of this top-down construction of the European Union, but also in a more horizontal way, if there are a more common quotations transplant by constitutional curves. And just a brief reference that is very relevant as well, what Pablo was in relation to the uses after the succession process from Catalonia. And it is true, you can find the references to the constitutional court in most of the judgment of decisions, especially in 2014 about the proper way of amending the Spanish constitution to celebrate a referendum, and saying that there is still a democratic room, there is no need to go to the facts. And also, not only in the Spanish Constitutional Court, if you go to the famous judgment of October 2019, where the secessionist leaders were condemned, you can find as well there many references to comparative law. I remember at the moment, not only the usual amount about the Quebec secessionist movement, but they really did from the 250 pages, I think was the judgment, there are at least 20-25 in relation to comparative law arguments. So the influence of the process is there as well.
Okay, so very brief final remark. How about errors in quoting? Because I would be very curious to see if the quotation is proper or just wrong, which I find sometimes in quotations, even at Italian level. But I don't ask I don't want to have any answer to that. But I don't. It's not the holy grail when you cite someone else. It's good to check if the quotation is proper or not, and sometimes it's not. Well, so it's just a very practical suggestion. Okay, now we go to the last panelist, Viktor KAZAI, and I give the floor to you, and please give us some information about your CV, and we are happy to listen to your paper on the rule of law. Okay.
Thank you very much for the opportunity. Yeah, it's an honor to be here among you, and I hope you will find my presentation interesting. I'm an SJD candidate or doctoral candidate at the Central European University, or as some of you may know it better, the George Soros University, which is now in Budapest, but we are actually relocating to Vienna.
Sorry, KAZAI, we can hear you very, it's very bad. I don't know, maybe it's the headphones or the microphones, but we can't hear you well.
Any better now? Is it any better now?
I don't know. I'm just trying to see if maybe you can reduce the volume. You reduce the volume and you speak louder.
Or you try to switch off the video.
Okay, is it any better now?
If you speak loud, let's see if you can speak. Sorry, but it was before it was wrong.
Sure, of course. Yeah, so I was saying that I'm a doctoral candidate right now, and I am focusing on my research topic is a judicial review of the legislative process.
Listen, you have to speak slowly and clear because the audio is not good. Okay, try it again.
Okay. I'm sorry, I don't know what the problem is with the computer. So the topic of my presentation is the strengthening of the rule of law through the judicial review of the legislative process. And let me begin by giving you a short explanation why I'm interested in this topic. The reason why I got interested in this topic is because what we can see after 2010, after the entry into office of the Orbán government in Hungary, is that the governing majority instrumentalized the parliamentary legislation to an extreme extent. It means that the governing majority uses the parliament for no other purpose than to enact its legislative reforms as quickly as possible, without any compromise, without any consultation, without any deliberation, without any careful examination of the laws. And what strikes me very often is that there is a narrative on the European level saying that the illiberal trend of Hungary, or in Hungary, could go unnoticed for a very long time because the governing majority respected the formal requirements of the rule of law. But this is a lovely narrative, but it is actually not true, because what we can see is that this extreme enthusiasm of the governing majority resulted very often in procedural irregularities, in very serious procedural irregularities in the parliamentary legislative process. And I always looked at the Constitutional Court, whether the Constitutional Court is willing to exercise strong control over the parliamentary legislative process. And unfortunately, what I saw is that the Hungarian Constitutional Court is not really willing to do that. And in the beginning, I thought that this is a Hungarian problem, that these barbarian Hungarians are not able to make proper decisions in the right way. But then I started to approach this question from a comparative perspective. And what I can see is that these sort of procedural irregularities and the abuses of the procedural rules is actually not uncommon, even in well-established European democracies and even on the level of the European Union. And basically what I'm trying to do in my research project is to argue for a stronger role of the judiciary in protecting the integrity and the constitutionality of the parliamentary legislative process. So the first part of my presentation, I'm arguing that these irregularities, these abuses of the rules of procedure in the parliamentary lawmaking process is not only a political, but also a legal issue, and what is more, a constitutional issue. In the second part, I argue that in order to be able to fully appreciate the constitutional significance of these irregularities, we need to adopt a rule of law framework, because these procedural irregularities ultimately undermine the rule of law principle. In the third part, I argue that one of the most effective enforcement mechanisms in this field to make the rules respected by the political actors is the judicial review. And the fourth part is basically just a list of the entry points where the judges, where judicial review can enter into the legislative process and enforce the rules of the game against the political actors. And if I still have some time, I will give you some specific examples how this kind of procedural review works in practice. So let me start with the first part. In the first part, I'm basically arguing that, yes, on the one hand, we can say that what happens in parliament, that what happens in the political process is a political game. Because from the perspective of politics, the lawmaking is nothing more than and nothing less but a formalized mechanism of political conflict resolution. However, we must not forget that in every constitutional democracy, the lawmaking process is actually a rule-governed exercise of state authority. It's regulated by the Constitution, it's regulated by parliamentary acts, and it's regulated by the standing orders. Now, as long as the political actors are willing to accept the rules of the game and make political decisions by respecting the procedural rules, we have an equilibrium. We have a perfect ideal state. However, the problem is that political actors have very often strong incentives to disrespect the rules and to violate these rules. Now, what I'm saying is that when they disrespect these rules, it's not only a political issue, but a legal issue, and what is more, a constitutional issue, because it ultimately undermines the rule of law. Now, this topic, this judicial review of the legislative process, I know it exists in many jurisdictions. However, in comparative constitutional law, what I see is a lack of a comprehensive theoretical framework to discuss all sorts of procedural irregularities. So this is why I think it would be very useful to put this whole question in a rule of law framework and understand why these procedural irregularities are the violations of the rule of law principle. Within the rule of law principle, it's or the conceptions of the rule of law, it's widely accepted to make a distinction between the formal conceptions of the rule of law and the substantive conceptions of the rule of law. Now, the formal conceptions of the rule of law, they obviously address only the former characteristics of the law, such as the publicity, such as the generality, or the consistency of the law. But I argue that there is one very important aspect of the formal conception of the rule of law, which is not very often discussed in the literature, which is the procedural regularity of the lawmaking process. In other words, I am saying that valid law can only be created in compliance with the rule of law procedure, the rule of law principle, if the parliamentary procedure is respected. So if the parliamentary actors, the political actors commit serious procedural irregularities, they violate the formal conception of the rule of law. And why do I think that? The primary reason why I think that is that if we accept the theories of Hans Kelsen and H.L.A. Hart, and I assume that most of us is quite familiar with Kelsen and Hart, then we can see that valid law can only be created if we follow the rules of the legislative process. If we do not follow the rules of the legislative process, the law will be invalid. And if the law is invalid, it's simply non-existent. So we cannot talk about the rule of law because there is no law at the first. There is no law in the first place. So that's why I think that if we commit a procedural irregularity, it will lead to the invalidity of the law. The invalidity of the law means that the law is contrary to the rule of law principle, and if it's contrary to the rule of law principle, it's unconstitutional as well. Now, for those who think that this approach is too formalistic, I offer an updated version of this approach, because I think that we can also approach this question from a value-based perspective. This value-based perspective means that basically when we talk about the rules of the legislative process, we are not talking about mere technicalities or mere formalities. No, we are talking about rules which manifest, which embody very important principles of constitutional law. So, for example, when we talk about the rules of the deliberation in Parliament, we are talking about the principle of equality of MPs. We are talking about the principle of democracy. We are talking about the principle of rational lawmaking, of the plurality of the society. So when political actors violate procedural rules, they not only violate technicalities, they not only violate formalities, but they very often violate the principles behind these rules as well, such as the equality of MPs, or democratic legitimacy, or the respect of the diversity of the society. So this is why I think that irregularities of the legislative process is not simply a legal issue, but it's a rule of law issue. Now, there is, in many jurisdictions at least, not everywhere, but in many jurisdictions, there is a enforcement mechanism to make these procedural rules respected by the political actors, which is the judicial review. Interestingly enough, in the international comparative constitutional law literature, when scholars discuss this question of procedural review of the legislative process, they very often trace back the origins of this kind of review to the seminal work of John Hart Ely, Democracy and Distrust, published in 1980. Now, in this work, Ely argues that the best way to interpret the American Constitution is to see it as a means to construct the political decision-making process. So, for example, the reason why the freedom of expression is protected by the US Constitution, because the freedom of expression contributes to the healthy decision-making process under the US Constitution. And many scholars derive the necessity of the judicial review of the legislative process from this kind of scholarship. However, I argue that in Europe, I don't think we need John Hart Ely to justify this procedural review, because we have European origins as well. And we can start with the theory of Hans Kelsen, who is often credited for being the father of the European type of judicial review. And in his theory, we know very well that the primary function of the Constitution is to regulate the organs of the state and the process of lawmaking. So it's only natural that under his theory, the judicial review necessarily extends not only to the substance of the law, but also to the process in which the law was enacted. And in fact, I found several articles from the 1950s and 1960s, which actually argue that in the first half of the 20th century in Europe, the procedural review was much more common than the substantive review, which is obviously not so surprising, because we know that the human rights boom or the fundamental rights boom came after the Second World War. So what I'm trying to do in my research and in this paper as well is to shift the attention back to another type of judicial review, which is not so much concerned with the substance of the law, but which is more interested in the process in which the laws are enacted. Now, let me briefly summarize what can be the possible entry points where judges can intervene in the legislative process. There are three main areas, I think. The first big area is all the decisions which concern the domain of parliamentary legislation. In other words, delegation of legislative power and distribution of legislative power. So when the governing majority and the parliament decides whether something should be regulated in government regulation or in parliamentary law, it's a procedural question which needs to be very vigorously controlled by the Constitutional Court or the Supreme Court, depending on the model of judicial review. The other main area where judges can intervene and protect the rules of the lawmaking process is basically everything which happens within the chamber, within the parliamentary chamber. For example, the initiation of legislation, or for example, the amendments attached to the original bill, or for example, the control of the quality of the parliamentary debate, the voting procedure, the necessary majority requirements, and so on and so forth. And the third main area, which is relevant for this type of judicial review, is basically everything which concerns the relationship of parliament with external actors of the legislative process. For example, I think about public participation, whether the people, whether trade unions, professional organizations, state institutions, and so on and so forth are allowed to participate in the process. Or impact assessments, whether the governing majority complies with its statutory obligation to always carry out impact assessments before the introduction of legislative proposals, and so on and so forth. So I think that these are the three main areas where judges can intervene in the legislative process and make the rules respected by the political actors. And if I still have some time, I would like to give you three very specific examples from 3 European jurisdictions in order to illustrate my argument. The first one is the case.
You have some time. You have approximately 5 to 6 minutes. So
thank you.
Take your time.
So the very first example is from France. In 2014, the French Constitutional Council examined the legislative provision which authorized the government to adopt regulation on gender parity requirements in certain state institutions. So on the face of it, it's a lovely provision because it's about the enhancement of gender equality. Great. However, the law was found unconstitutional on a purely formal basis. And why is it so? Because in the course of the lawmaking process, the government extended the original request of delegation of legislative power. And this is something which is prohibited by the French Constitution. If the government wants to get a delegation of legislative power from the parliament, it has to be in the original bill introduced in parliament. What the government did in this particular case is that it extended the original request of delegation of legislative power. And even though it was for the good cause, it was for gender equality, it was found unconstitutional because it was a serious violation of the procedural rules stemming from the Constitution. I will give you a Hungarian example as well. In 2011, the Hungarian Constitutional Court examined the constitutionality of a church reform bill. Now, this church reform bill was found unconstitutional because the governing majority amended the original bill right before the final vote in the parliament. However, the justices actually realized that this amendment was not a simple amendment to the original bill, it was a complete revision of the bill. So the governing majority adopted this strategy to let the media and let the parliamentary opposition discuss the original version of the bill. And then right before the final vote, by way of introducing an amendment, they completely revised the whole legislative proposal. And the Constitutional Court found this practice unconstitutional because it violated the standing orders, which represented a very important constitutional principle, the principle of careful deliberation and careful examination of legislative proposals. All right, thank you. I think I respected the time limit.
Oh, sure. Thank you. Thank you very much. It was very clear. Your time is okay. And therefore, I open the question and answer session. First of all, I have Alessandro Somma, Professor Somma, and then Paolo again, Paolo Passaglia.
Yeah, thank you very much for your presentation. I have a question. From a procedural point of view, which is your point of view, also social conflict is very important for the process of lawmaking. I mean, democratic social conflict, of course, somehow ruled social conflict, but a social conflict which needs a very broad extension of democratic prerogatives. Don't you think that relying too much on the role of the judiciary could lead to a technocratic point of view, could lead to a situation where social conflict is neutralized, individualized maybe also, but in any case, not at the center of the process of lawmaking. What is your concern about social conflict, democratic social conflict, I stress again, in between your idea of procedural approach?
Thank you. So I think that, well, to be honest, I'm not a big fan of constitutional courts. So this is not the reason why I argue in favor of a stronger judicial review of the legislative process. The reason why I'm arguing for a stronger role of the judiciary is because we have formalized mechanisms to resolve political conflict. And if procedural irregularities happen, it's because the actors of the political conflict are not able to resolve their problems through these formalized mechanisms. So they have all the democracy they want, and they have all the procedures and mechanisms to resolve their conflicts in a formalized mechanism. But when they fail to do that, this is when the judiciary has to enter into the picture and correct the procedure. And in this way, the judicial review of the procedure, again, it has nothing to do with the substance. So the only thing that the judges will do is that they throw back the legislative proposal to Parliament to conduct another democratic procedure, but they will not say anything about the substance of the law. So I think that this approach actually reinforces the democracy, the parliamentary democracy, because it actually says that, guys, you have democratic rules, respect them. This is why you are there. And I understand that, yes, Parliament has prerogatives, Parliament has autonomy. So I'm not saying that every little mistake in the process should be reviewed by the court. Yes, of course, the court has to show some deference to the political branches. But there is a reason why lawmaking is regulated. And I think it stems from the rule of law principle that we cannot disregard these rules. Otherwise, there is no point in regulating the lawmaking process. Otherwise, they could just give guidelines to politicians how to make law if you want to. But then there is no point in regulating this in the constitution, in parliamentary law, and in the standing orders. This is my point of view. I hope I answered your question.
Okay, thank you, Paolo. Paolo Passaglia, Professor Passaglia.
Thank you for your presentation. It was very interesting. And I agree with you, especially with regard to the answer that you gave. Simply, I would suggest to create a close link between the procedural unconstitutionality and the system of constitutional adjudication. Because in my view, much depends on the way in which you can allege unconstitutionality, procedural unconstitutionality. For instance, if you, several years ago, I tried to compare the Italian legal system and the French one. And I saw that the Constitutional Council has a very rich case law concerning procedural unconstitutionality. Why? Maybe because there is a constitution in which there are many provisions concerning the lawmaking process, but then also because of the standing of parliamentary minority that is interested in making the Constitutional Council decide on procedural unconstitutionalities. Whereas in Italy, the Constitution doesn't really say anything about, or there are just a few provisions on legislative lawmaking process. But also because the Constitutional Court doesn't have a way to be seized with specific regard to procedural unconstitutionalities. Minorities in Parliament are the most interested subject to let the court decide on those issues. But Italy doesn't have such a standing. And if I were you, I would just have a glance to the most recent constitutional case law in Italy, because the Constitutional Court was asked to decide on conflicts between branches of the state, powers of the state, and was asked to decide on procedural unconstitutionality. And the Constitutional Court try to limit its scrutiny, because otherwise the Constitutional Court would be obliged to decide on loads of would risk to be obliged to decide on loads of unconstitutionality. Probably because there is no constitutional provisions concerning, for instance, the amendment process in the legislative process. And so the Constitutional Court would have to find an interpretation that would be very, maybe sometimes seen as arbitrary, and would lead to a number of appeals that would create problems in functioning of the Constitutional Court. If you compare with the French system, you see that there are some principles that are provided directly by the Constitution, and so the Constitutional Council doesn't have to interpret it, doesn't have to create with an arbitrary method the limits, the boundaries of its scrutiny. So I think that, to conclude, procedural unconstitutionality is closely related to how the constitutional framers established the constitutional protection and how the constitutional adjudication system is framed. Thank you.
If I might just add one brief comment to Professor Passaglia's remarks. He was making reference to the case is very important because it concerned the budget session. And as we know, budget is the main moment in which democracy is somehow demonstrated. Members of parliament have rarely a saying in legislation. So I think this is and the way through which the Italian Constitutional Court took a step back saying, I will not enter this field. Well, it's very interesting because Professor Pazzaglia pointed out what the consequences of a different decision would have been. But I think the point is, budget session is essentially has very much to do with procedure and with parliamentary procedure and what kind of amendments can be inserted, what you can put in the budget. The Italian budget session is something which is thousands and thousands of provisions, 1,800, between 1,500 and 1,800. So it's very interesting. I'm just pointing this as to Viktor KAZAI. Could be interesting to see how this specific aspect in a country which up to now does not have dramatic constitutional conflicts, or this procedural approach to the rule of law can be very important.
Yes, just a remark from my side to our scholar. You have also to keep in mind that it's procedural problems are not only a matter of judicial review of legislation, but also a matter of conflict between powers, because the case cited by Professor Passaglia and Professor Zenozenkovic were put in place not in the area of reviewing the legislator, but in the area of conflicts between powers. So it's also a matter of focusing on specific, if you want, I mean, you can broaden your observation to conflicts between powers, or just stick on the view of legislation, which encompasses also the matter of giving evidence to procedural wrong procedural implementation. And there also some courts, I don't know if our courts, but they are very careful in asking for evidence of wrong events in the area. So it's a very interesting matter you are approaching. So my compliments and good luck for your future studies.
Very quickly react just in
sure, you are welcome.
Sentences. First of all, thank you for the comments. I fully agree with the argument that different characteristics of different constitutional courts or constitutional have to take into consideration. Yes, obviously, the reason why the Conseil Constitutionnel is so active in this field is because the drafters of the Constitution were very afraid of a powerful parliament, and they wanted a strong executive. And this is why they inserted many provisions in the Constitution about the parliament, and this is the reason basically why they set up the Conseil Constitutionnel. However, even the Conseil Constitutionnel, despite the many provisions in the Constitution, there are several cases in which the Council simply derives principles which are simply not present in the Constitution. For example, the quality of the debate. Now, the Constitution doesn't say anything about the quality of the parliamentary debate, but it has become an integral part of the jurisprudence of the Constitutional Council to check whether the quality of the parliamentary debate is actually sufficient or not. The other thing is that this is going to be one of the main areas of my research, I think in chapter 2, in which I will look at the different ways in which these kind of cases can be litigated and adjudicated by the court. Yes, of course, the obvious solution in these cases is that the opposition simply challenges the law before the Constitutional Court. However, we can also see in many jurisdictions very creative ways of channeling this kind of constitutionality in the adjudication of cases. For example, it exists in Germany, but it also exists in Hungary, that in a constitutional complaint mechanism, the applicant can argue that his or her fundamental right was violated because the enactment of the law which interferes with her right was actually full of procedural irregularities. So there are creative ways of circumventing this kind of difficulties. And thank you very much for the Italian examples. I know that it exists in many jurisdictions. I know that Spain has a lot of jurisprudence on that, for example. Unfortunately, not much has been written in English. And, you know, I can only do research in the languages I speak, and it's only 3 of them. So, but I will try to do my best to expand this. Thank you very much.
So you have to come to do vacation in Italy so you can broaden your skills in the languages. Okay, so my dear colleagues and panelists, I think we are now getting to the conclusion of our session, and I was very interested in listening to all the papers and the discussions, and I know that the Congress is running in a very broad way. So we will be again in the next session to listen to other papers and to other discussions that are really very interesting and very important. So
if I may just add, just to say, well, thanking everybody and thanking Professor VIOLINI for having chaired this session. Just tell you that the next session is this afternoon at 4 o'clock Central European Time. The session on Islamic and African law, chaired by Professor Scaffardi. We have papers by Leonardo Almeida Laghe, Cihan Benarafa, Adriano Dirri, Marco Rizzuti, and Sayed Mohammed Amin Zavarei. So there's going to be a rich panel, multicultural panel this afternoon at 4 o'clock. So for those who are interested, the appointment.
So thank you to everybody, and see you in the afternoon.
See you.
Bye-bye.
See you.